Morning.
If I may, my lord, I beg to mention item number 11.
Yes.
Yes, my lord, I'm appearing for the appellant. I beg to mention item number 11. On the grounds that Mr. A. Sattar is unwell. Hence, the matter may be taken up on.
You've taken consent from the other side?
Yes, and for the respondent, my lord, my only humble submission, my lord, that may be fixed, my lord, on second break of
As prayed for by Mr.
G. Imtiaz, ma'am.
G. Imtiaz, learned counsel for the appellant on the ground that Mr. A. Sattar.
Yes,
The
yes, sector.
yes, ma'am.
A. Sattar or S. Sattar?
A. Sattar.
A.
A. Sattar, ma'am.
A. Sattar, learned counsel for the leading counsel for the appellant is unwell, comma, with consent from the other side, list this matter again on such and such date.
Yes.
Deeply.
Okay. Well, item number 8. Well,
8.
well, in this case, well, the earlier well, the leading counsel KP Sharma, well, is expired, well, and the entire records were with him. And
You are appearing for the appellant?
yes,
Your name?
PG Saini.
Mr. P.J. Saikia, learned counsel for the appellant, submits that upon expiry of the earlier engaged counsel, he has been newly engaged and he is
No, my
trying
lord.
to
I'm
reconstruct.
also there with Mr. KP Sharma, my lord. But
When?
the records are with him, my lord. I could not, my
If
lord.
you are on record, why you don't have the records?
Entire records are with him, my lord, senior counsel, my lord. And that could not be, my lord, taken.
How much time will you
2
take?
weeks time, my lord.
What, Mr. So-and-so learned counsel for the appellant submits that he may be allowed 2 weeks time to reconstruct the records in view of the fact that the leading counsel, Mr. So-and-so, has expired in the meantime. Give the names. List after 2 weeks on a date to be fixed by the registry. With
Alright.
consent.
PG
Naam to
Saini.
loi logo.
My name is
Yes.
Deep Borua.
Yes, next matter.
Mention will be made up supplementary list 12. Mr. P. Khatonier is having high fever today, so he is unable to conduct the hearing.
Mr.
P.
Khatoniya is not well.
Not well.
Have you taken consent
Yes,
from the
I
other
have.
side? You're appearing? Any objection?
No.
As prayed for on behalf of Mr. P. Khatonier, comma, with consent of the other side, list this matter again on
2 weeks, you know.
after 2 weeks date, they were 50
Lordship.
on such and such date.
Excuse me, Lordship. If it's possible, the interim order may continue till the next day.
Interim order, if any, shall continue till the next date of listing.
Okay.
May I please, Your Worship? Here in this case, the sole appellant has expired long back. So the appeal has awaited in the meantime. So at this stage, since I have not filed any application for substitution, the second appeal may be closed, keeping it open for filing of the appropriate application. Keeping it open for filing of the appropriate application. Now, in the 2019, the sole respondent expired.
Expired.
So, yes. So it is abated.
This is an SAO,
Yes, sir.
43(1)U.
Yes.
Yes, Mr. Datta?
Yes, my lord, the expired long back 2019.
He is the sole,
Respondent.
Yes,
you are for the respondent.
yes.
So I'll close it in view of the endorsement made by you. Mr. S.K. Ghosh.
SP Choudhury.
Heard Mr. S.P. Chaudhary for the appellant. Stop. Also heard Mr. S. Datta, learned senior counsel, assisted by Ms. S. Mushahari, learned counsel for the respondent.
Yes.
Stop. Mr. S.P. Chaudhary, learned counsel for the appellant submits that the sole respondent,
Rajat Borua.
but on the death of sole respondent Rajat Bora, his legal heirs were substituted.
No, this legal heir, the wife was substituted, Lordship.
Yes.
Yes, the wife also expired.
No, and daughter is there, Mala Singh. You all do not open your briefs.
My learned friend told me that they did
No,
not file any.
please have a look. It'll dikhai diyo.
The order has been passed, Lordship.
Please have a look,
Yes.
Mr. Chaudhary. You see, this court takes whatever you all submit
I'm
very
sorry, Lordship.
seriously.
Oh, the substitution part is there. Actually, I tried to get it from the. I'll get the instruction with regard to that. Can it be taken?
Dr. Saraf, I think that matter has been wrongly listed. So I am informed it has, because I already reserved it. You have come for that matter? Yes, yes, I have received it and it's been already reserved.
It's already,
I'm sorry,
the
Lordship. Some
record has been corrected.
confusion is
You
there.
all have to
Yes.
take some responsibility, Mr. Chaudhary.
Yes, I'm sorry,
When
Lordship.
you
I'm
make
sorry
a
with regard to that.
submission before the bench, you must be careful of what you submit.
Even the Okalatnama was also submitted with regard to the substituted.
So I'll adjourn it in the
Yes,
meantime,
I will obtain the instruction, Lordship.
because I don't think you are prepared today.
Otherwise, the SAO with regard to the remand of the case, so it can be otherwise taken up because I have the information from the petitioner that they are not interested in pursuing the matter also because of the demise of
Point
the
involved is very short.
respondent.
It was remanded on the point of maintenance.
Maintainability.
Yes.
Was Mr. Shokuna? It is not reflected, Lordship. Kindly this some necessary direction. It is not.
Already in the record.
Yes, it is on.
Anyway, you verify.
Yes.
I'm adjourning it
Yes,
today.
yes. Lordship. Was Mr. Shokuna?
Mr. SP, list this matter on list this matter after 1 week. List this matter at a date on such and such date to enable Mr. SP Chaudhary, Learned Counsel for the appellant, to verify as whether the legal heirs of the sole respondents have been substituted. Stop.
All right.
Mashra, when you bring this order, bring the file.
May I please, Your Lordship? Your
Yes.
Lordship, kindly the matter may be passed over for the time being as the engaged counsel is on leg.
Mr. Chaudhary,
Yes,
HRA Chaudhary,
Yes.
what is this matter? It
R.
is,
Chaudhary, Lordship.
hmm?
R. Chaudhary.
What is this matter?
My lord, I am the plaintiff respondent over here. My suit was for correction of my sale deed along with right title interest. It was dismissed.
This is right, Chaudhary, then you wait for some time.
My lord, can it be taken up on 6th, 5th or 6th, my lord?
Then I do not understand what is the requirement of having these matters on the top of the list.
That is, my lord, I came prepared for that.
Anyway, it is submitted that MS.R. Chaudhary, the leading counsel, is engaged in another court when the matter is called. Stop. List this matter. Yes. When?
My lord, let it be on 6th
On such and such date.
of last.
All right, Lordship.
Steps has been taken, my lord, an alternative address at Kolkata. This is a builder.
How many respondents
3, my lord. 1 is the main respondent
you are
builder.
appearing for?
Respondent number 3.
3.
Yes.
Who are 1 and 2?
1 actually not appeared. That is why we have taken our steps in alternative address. And I think he is received them. Office note 27/8.
27/8 says neither AD card, unserved notice by registered step as well as service report by usual step received back for R1.
Oh, I think he is received. So we may wait.
Await service in respect of respondent number 1. List after 2 weeks and a date to be fixed by the registry.
Oblige, sir.
Yes, that part heard matter. Yes, Mr. Rasgupta.
So far this award is concerned, well, I have gone through it. Actually, on 2 counts, the learned presiding officer granted award. Only he proceeded with the
Let
premises.
us not, we will not reiterate the submissions that you have already made. Extensive arguments otherwise have been made by you also on the first day. And so if on the last occasion, while you had submitted your written argument, you said you wanted to make some additional arguments. So if you have anything in addition to say,
Yes, yes.
please say that.
So for the additional point that I had not heard earlier, not that I would like to argue. Basically, this is a conciliatory settlement. Now, my line of argument is that the conciliatory settlement.
You have referred to section 18.3.
Section 83 along with section 2P and 19.2.
And?
19.2.
18.3 and then?
19.2.
19?
19. Section 19. Subsection.
Section 19, subsection 2.
Probably. Section 19.
Yes, please.
Now, it will just come to section 2P, Milord.
Section?
2P.
2P of 19?
No, 2P of the Industrial Dispute Act.
Definition clause.
Definition clause.
2P. Yes. Yes.
Settlement. Settlement means a settlement arrived at in the course of conciliation proceeding and includes a written agreement between the employer and workman arrived at otherwise than in course of the conciliation proceeding, where such agreement has been signed by the parties thereto in such manner as prescribed, and a copy thereof has been sent to such and such, shall be the appropriate government and the conciliation.
The purpose that you are referring to the definition of settlement and relying on section 18.3 is to show that these conciliation proceedings are binding. Correct? This is the purpose?
Not only that, in addition to that, Milord, this conciliation settlement has a force of law.
That is why it is binding.
That is why it's binding, and it should be considered as an instrument of law.
All right.
And as it is an instrument of law, Milord, it should be strictly complied with.
We accept it. We accept it.
That's all.
I remember the facts, Mr. Tiwari.
It is strictly complied with it. And another, and while complying with this settlement, if you deviate from the settlement, then a fresh settlement has to be made.
But it is nobody's case.
Yes, it is my case, it is the presiding officer's case, it is their case.
That is not their case that there has been a deviation from the settlement. According to them, the settlement was subject to conditions. The conditions have not been satisfied. Therefore, the settlement has not been given. In short, I am saying that is the sum and substance of the argument from the other side. In fact, a plain reading, Mr. Das Gupta, of the settlement also indicates that.
Yes.
And this is a revision. Ultimately, I am exercising powers under certiorari here. You have applied under what? 226 certiorari. So it is only if the error is apparent on the face. That is the limited jurisdiction. You have referred all these decisions in your written arguments. Correct? Now, keeping that principle in mind, if the judgment impugned is looked into, it appears there has been an error because the labor court has gone outside the scope of the reference number 1. That could not have. So, on that I am saying.
Any point? Any other?
Sorry?
Any other point there?
No, this is one thing. I am only I am expressing this so that while you are replying, you address the anxiety.
So
of the
basically,
court
your lordship's anxiety is that the labor court went beyond their jurisdiction. They have tended to the other point.
Appears, and this is one of their arguments.
That
so
is
since you are
argument.
replying, this is what you will have to reply also, because otherwise, you see, the binding thing is accepted. Section 18.3 18(3)(d), which these are a position of law, there is no quarrel. Now, anyway, you develop it.
No, only Labor Code dealt with the 2 points. First point was the learned presiding officer was the view this is not a conciliation settlement, it is a camouflage of settlement. And on that point, your lordship pointed out that he cannot go beyond that. When the terms of reference is made, and on that day I tried to substantiate my argument by referring section 10(4). And it seems to me that your lordship was not convinced on that day. So I will not insist on that.
All right.
Because on that day I tried to impress your lordship by referring section 10(4), but to bring the point that yes, the Labor Code can look into the other other incidental point. And I think your lordship was not satisfied with that point. So I will not keep.
All right.
Now, the second point is that what they wanted to see, that there was a revision of pay scale, two revision of pay scale. And they said that though you have not complied with NPC target, but we offer it to you. Am I correct? That is their contention. First contention. Now, when it is a conciliatory settlement, it is a legal instrument or it is a force of law, you must comply with all the provisions as contained in the settlement. You can
All the provisions.
all the conditions. All the conditions, because it should be considered as a statute.
Strictly complied.
Strictly complied. Now, you cannot say that though you have not complied, though you have not complied with, though you failed to produce the
But
NPC
Mr.
target.
Dasgupta, if that settlement itself stipulates that condition, that subject to fulfillment of so and so condition, so and so will be complied. If it is subject to that condition, if that is the condition precedent for fulfillment of the terms of the settlement, in that case, how can you say that
Yes,
notwithstanding fulfillment
No,
of the
but
condition?
if your lordship come to this point, then it will be easier on my part.
Yes.
Then it will be easier on my part. I will not argue on this point. Now they have complied with these two things.
Complied with these two things means?
Sections.
No, they have complied with. I'm sorry, I didn't get that. I'm sorry, I didn't understood your last argument. What do you mean by saying that they have complied with?
Yeah,
the
let us
last two
go through
conditions
settlement first, page 31
of the petition?
of the writ petition.
Yes, I have it. Management as a goodwill gesture.
Yes.
Yes.
Management as a goodwill gesture, they have extended this revision of pay scale.
Yes, but you have to read it. What it means. Will offer.
Now clause 2A.
Yes.
Keep on, I will not argue only.
No, you take your time, Mr. Dasgupta. All the
No,
facts
as your
has to be
lordship
clear.
has understood these things, I will not spoil the time.
It is just that I don't want unnecessarily to be reiterated because extensively both parties have also given your written arguments, which I have read. So whatever you want to clarify, you clarify. No issues.
But
Yes.
Number clause 2A,
Yes.
page 30.
Yes, I have it.
Revise the wage of the workmen covered under this agreement at an average of rupees 1569 per workman per month. Detailed calculation would be worked out due course as per prevailing practice and other. Revision will be effective after the achievement. That's after the achievement of the productivity continuously 2 months. Effective date of this revision will be first day of the following month.
Yes.
Now they have extended this benefit. So what is the presumption? They will have completed NPC. Now they want to say, no, you have not done it, but as a gesture of goodwill, we have extended it.
Yes, but then Anyway, yes.
To fortify this thing, if your lordship comes.
I don't want to keep interfering when
No,
you
no, no, no.
argue, but you see, A is part of 2, correct?
Oh.
So you have to first read from 2. What does clause 2 say? That the workmen would achieve and maintain the productivity norms as per the base productivity study report by the NCP management. By the NCP management would then, now this word then here has some significance, agree to the following settlement of the charter of demand of the union.
So only thing
Correct.
you
So this then seems to be of some relevance here.
Yes,
because it seems it is conditional that the workmen would achieve and maintain the productivity norms.
that is the sole only point.
Yes.
That is the only
Now,
point.
this court certainly cannot interpret this because it is unambiguous. Correct? Both parties
Very
have
much clear.
understood it. It is very clear.
Very much clear.
It is
Let
very
us-
clear.
we should not
Yes.
skip it all.
So then
So
let's
only
proceed.
condition is that whether this NPC target was fulfilled or not.
Correct.
That is the sole point.
Correct.
Now, if it is fulfilled, then clause A, clause B,
Clause C.
and clause C as well as the clause D.
Yes, because clause D makes it further clear. The strict adherence to NCP norms and achieving and maintaining agreed productivity norms from the date of resumption of operations.
So, if the NPC has been fulfilled, then clause A, clause B, clause C will
All
be
right.
complied.
So now let us read the next part of clause 2. Management as a goodwill gesture will offer. Yes, please read.
No, let us.
Okay,
we have
okay.
gone to clause A.
Yes.
The so far clause A is concerned, they have complied with it.
Okay.
That is there.
All right.
I should not trouble your lordship by going to the evidence. It is there. It is in the evidence itself. So far clause B is concerned, that was also complied with.
All right.
So after compliance of these two clauses, they now cannot say, you know, though you have not fulfilled this NPC, but as a gesture of goodwill or something like that, we have given it to you.
Now that 1 crore is left to be given.
Oh.
That lump sum that is to be given, isn't
That
it?
is subject to the fulfillment of NPC. And now we have given A and B.
According to you, since A and B has been given, that is why that means that these productivity norms have been fulfilled, and therefore you cannot turn back and say, "Ki, no, it is not fulfilled."
Right.
This is what
For
you are
that
saying.
purpose, for that purpose only, I would like to refer this section 18 and 19.
Okay.
I will
Okay.
later, because your lordship has gone through it, and I should
Okay.
not trouble your lordship. Now, second point is very much clear. Now, this settlement specifically states that you should take the initiative to initiate whether they have achieved this productivity NPC. Whether the workman has achieved this NPC, and what is the date. They have specifically stated in clause A.
First day of following month.
Sorry, clause 2A. The effective after achievement of productivity continuously for 2 months, effective date of this revision will be first day of the following month. Next. Now, it was incumbent on their part to calculate it. And for that purpose, there is a clause. I will not trouble your lordship. If required, I will.
You let me know the clause. I'll take a note.
Yes.
Clause.
Clause is probably the clause 31 or something like that. 31.
31.
Page 37.
I think 30 or 31.
30. I'm sorry, 30. Page 37. it is agreed by the parties to the agreement that the management operators would give detailed production reports against the targets along with the for reasons for shortfall. If any, operators would be responsible for quality of parts produced. Any failure, excess, rejection shall be treated as a gross misconduct, etc. It is further agreed that any failure to give daily signed production report would amount to absence of the duty. So there is no dispute that they have not furnished all these things. And it is also specifically admitted in their evidence also. Now, it was incumbent on their part to assess the productivity from the 1st March of next month, 1st day of May. Now, they have started to they have started it from the date of date is assessment was started from 1/2/2013. That your lordship will
Yes.
page 16, para 20. Page 60, 60.
Yes. Exhibit 9.
Exhibit 9.
Worksheet 1/2/2013.
2013. They have started. And according to them, you could not achieve these things. Now, initially you disbursed this settlement, as disbursed is due as in terms of clause 2A. Then subsequently you disbursed clause 2B. It was incumbent on your part to assess this, and it should have been assessed from 1/2/2012, 1/3/2012, and you, like yourself, you have stated. And this part was also taken into consideration by the learned presiding officer.
All right.
But so far the other parts is concerned, probably he may be correct or he may be wrong. That is not, I will not press it now. That's what you want to say. It might be a camouflage, etc., etc. But so far this thing is concerned, he has taken into consideration. Now, at this stage, I would not trouble your lordship by reiterating all these factual aspects. Now, it seems to be that your lordship has gone through the whole this.
No, not only you can take if there is anything, but you have already argued at length as regards the factual aspect.
Yes.
And
so I will not.
Since you have already submitted your written argument, that is why.
No,
I will not stop you from arguing, but let's not necessarily repeat the same argument.
I will not repeat a single word. Now, so far, the settlement has a force of law. It is a statutory force of law. I will refer. Only some paragraph. But in this case of what happened, it is a case of LIC. In LIC, there was a settlement.
This is a huge, voluminous judgment. Yes.
So I will
tell me the paragraph.
Only paragraph 3.
Paragraph 3.
No. Page. No, just me. If I go through the if I state the fact, then it will be very much.
No,
easy.
that's all right. But
No.
paragraph, Mr. Dasgupta, which para are you relying of this decision?
Para 7,
Yes.
then page 9. Para 22.
7, 9.
Yes. 7, 9, 22.
22. Then 23, 19.
Hmm?
23
Yes.
and 24 that deals with section 19.
Yes.
Para 30. Page 16 is maybe important. Just I will read one line.
Yes, yes. You, of course, I will allow you to read all the paragraph, but first indicate the paragraph so that
Gotcha.
I can take a note.
Oh,
You
sorry.
see, once I close it and reserve it, it becomes very difficult if these things are not available.
Yes, yes.
Because at the end of the
Yeah.
day, I have to author.
Oh, yes.
Yes,
That is
please
correct.
give me the
Oh, yes, yes. Para 16, page 16.
7, 9, 22, 23, 24, 30.
Then page 16, yes, sir. Page 32. Page.
Your junior should have taken note of the paragraphs and put it on top of the judgment. I think generally
No,
this
no,
is what
page-
we do.
Page
Yes,
para 74,
yes,
para 77,
yes.
para 79.
Okay. Now,
No, let-
where do you want me to first go? To page 16?
Before going to that, all these
Yes,
things.
tell me.
What is the purport of those paragraphs is that the Apex Code referred the provisions of section 2P, section 18, section 19. After referring all those paragraphs, Apex Code came to a conclusion that settlement and award are standing on same footing. Second, third thing is that the award has a force of law. So settlement should have a force of law. This is,
All right.
so I would not trouble your lordship.
All right.
This is, award has a force of law and settlement should have a force of law, and both these two things stand on the same footing. For
Okay.
that purpose, I need not refer all those paragraphs. If you straightway, if your lordship comes to section 19 of the Industrial Dispute Act, section 18 and 19.
Section 18.
18 and 19. They have referred all these things and I came to this conclusion. 18. Have you got it?
Yes.
A settlement arrived at by agreement between section subsection is not required, subsection provision of subsection and arbitrary award as before enforceable. Again. 18.2, subject to the provisions of subsection 3, an arbitral award which has become enforceable shall be binding on the parties to the agreement who referred the dispute to arbitration. Except subsection 3, a settlement arrived in course of conciliation
So
proceeding.
here, that subsection 2 of 18 only makes it clear. The
Yes.
number 1, enforceable. If enforceable, binding. Correct?
And it is as good as an award.
No, there is no quarrel on that.
There is no quarrel. So if it is as good as an award and if it is a legal instrument, then all the provisions as contained in that legal instruments are to be strictly complied with. And again, I'm sorry for that. This is a very well-known case, Lord.
Yes, Najir Ahmed. Yes, it's well known.
Well known to all.
Power in the manner it is given has to be exercised. All other methods are forbidden. Correct.
It is also engaged in Article 154.
Very well. There is no difficulty in all this.
That is just page 7, internal page 7.
All right.
It can hardly be doubted that where a power is given to do certain things in a certain way, things must be done in that way or not at all.
Other methods are necessarily forbidden. Yes.
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 Other things are forbidden. So, my respective contention in this regard, I will close my argument now. When you by yourself has given the benefits as contained in clause 2A and 2B, the presumption is in my favor that we have complied with these things. And when you have not complied with the provisions of assessing NPC from the next month, it is presumption is in my favor.
Because they have failed to perform their part of the duty under the settlement. This is what you are saying, right?
Yes. So, in order to negate these things, Willard, it was argued that burden lies on us. Burden lies on us to establish that we have we have fulfilled the NPC. Now, it is the Fundamental Rules of Evidence Act. Burden lies on whom? Who assert it? It is your assertion that you have not fulfilled it. So it is your obligation. It is your obligation. You have initiated the proceeding. And that too not in the time, but 1 year after. So this is precisely what I argue on the last day, Lord. I argued on the point of that point, whether this is enforceable, and I found that your lordship was a bit different. So I will not argue this point at
That's
this stage.
up to you. I'll have to deal with
Because
all
we
your
have to win this case.
Sorry?
This much.
Sorry?
There is 2 points. So I will place this.
You see, Mr. Dasgupta, why the courts generally interact when the council
No, I fully agree with your lordship.
Give you an idea as which direction or how the minds of the court is also
I fully
dealing
address-
with the list in hand, so that you get an idea and accordingly you can address the court.
No, your lordship was absolutely correct.
So I don't remember, and till we don't sign the order, nothing is decided. So
No. Your lordship, on that day, your lordship was absolutely correct, because I am claiming my right under this settlement.
Correct.
If I am claiming under this settlement, how can I say that this is a camouflage? It will go against me.
All right.
So I can only speak on this point only, that it was incumbent on your part. And so far the other legal arguments are concerned that I have already
Yes. We have also
on
referred
record
to
or not.
Surya Dev and various decisions.
Just
Yes.
only one decision, the 26. I'll placing it to your lordship. I will give it to him also.
This
In
is
my
on-
written argument, I have pointed out all these things, paragraph 39 onwards. So I will not trouble your lordship.
These are those decisions on certiorari.
Yes.
All right. Ayurvedic science, yes.
Ayurveda. A recent
This
case.
is referred in the written argument.
I have referred in the written argument. So this much, Milord. I'm sorry, Milord. On that day, I
Why are
had-
you being sorry, Mr. Das?
because it was incumbent on my part to place this point.
No, that's all right. We are continuing with the hearing. No difficulty at all. Yes.
I'm much obliged as your lordship allowed me to argue this point. Like this much.
Anything, Mr. Tiwari?
Number one, it is factually incorrect that proceedings were initiated by us. It is they. It's part of the record.
Dispute
In fact,
was
yes, it's they.
raised by them.
In fact, the contention made from our side is, why did they wait for so long? They waited. The point of limitation was also taken. Be that as it may, it was, my lord, initiated by them. Number one. Number two, my lord, fine. Proper record was not maintained from the very beginning. But the fact of the matter is, there is a proper record from 1st February 2013 onwards. Did you meet the target then? Because my lord, settlement makes it very clear at every stage thereafter. Even in one quarter they fail, the whole thing collapses.
Page 30, it is that part of the settlement, right?
And
Yes,
so
yes.
far as
Page 30.
30.
Just let's revert back to it. 31. Mr. Tiwari, can
Milord,
you just
Sarah.
clarify one thing?
Milord.
Because after quite some time, the matter has again come back. So now this condition number 2 appears to be in two parts, correct? ABC is one of the conditions, A, B, C, D. And what is the part which is after D? Is that a second part?
No, consequence.
Can you explain me in how these conditions are to be understood?
Milord,
Just that
each
part.
of the
If you
condition-
can clarify that.
Each of the condition, my lord, is integrally connected with the fundamental condition of meeting the production requirement.
Correct.
That is fundamental.
Which is given
So-
in the beginning itself.
Yes, my lord. So that's the fundamental to it. So
Yes.
A, B,
Now
C,
say
D,
this
whatever
is-
you do, we will do this provided you do that.
Yes. Now, after what are the remaining conditions according to you? 1, 2, 3, 4. Just give me that.
Because the core of the condition was this, the fundamental, my lord. And the revision of wages is one part. It was, my lord,
No,
because
why there is a confusion? The management as a goodwill gesture will offer. Now, this is an addition of ABC.
my lord, yes, in addition of ABC.
ABC.
Eh.
And A and B has already been
And also
given.
the reinstatement is one part.
Correct.
And on reinstatement, my lord would recall, there was another proceeding.
That has
And
been
the
closed.
industrial tribunal came to the finding that targets are not met, they're not entitled to reinstatement.
Yes.
Reinstatement was denied. So revision of wages, we made it very clear. After all, my lord, a businessman and industrialist is a pragmatic person. Fine, to maintain peace and all harmony, there is always a hope. Fine, settlement has to be, my lord, settlement, one has to stick to the settlement. But if one is trying to be benevolent, benevolence, my lord, should not
So
be used.
in this dispute, in this list right now, we are only concerned with this one, this lump sum payment, correct?
Yes.
The rest has already been paid.
Reinstatement, my lord,
Isn't
it was decided
Correct.
against
So
them in a separate
ABC
proceeding.
has already been done.
Yes.
Now here, if I recollect, you said it is 3 conditions has to be fulfilled. Number 1, commencing after workmen have achieved and maintained the productivity norms
Yes.
as agreed above continuously for 3 months. This is 1, and thereafter every quarter.
Yes.
Now, according to you, it doesn't mean in the beginning you have completed and you will be entitled.
Yes, at every stage.
At every stage,
quarter.
because this makes it clear.
Yes.
The second condition. Thereafter, every quarter.
Every quarter.
Then the third is any failure in achieving and maintaining the agreed productivity norms in any month will disentitle the workmen to such lump sum amount, and management will deduct
Yes.
these lump sum amount from the wages of the workmen in the same manner as it is paid. So these are the 3
Precisely.
condition precedent.
Yes.
Correct?
Yes.
Have I left out
That's it.
anything?
Absolutely. Lordship has got it. No, my lord, merely because one can very well argue wages were revised, you made that very payment. If you have not met the target, why don't you forfeit that also? Why don't you deduct it? Why don't you recall it? Well, my lord, that's an industrialist trying to be pragmatic. So, my lord, our benevolence can't be used against us. The thing is, the core fundamental condition has not been fulfilled by you. That's the core issue, my lord.
And that's the error.
Yes.
Apparent. Because
Fundamental. And my lord, more
despite
importantly,
this being
yes.
fulfilled,
And
the labor
Yes.
code interpreted it in another way.
the fundamental error of industrial tribunal lies in the fact that the industrial tribunal has not recorded a finding that the productivity norms were met. Either you record a finding, no finding has been recorded, my lord. He has gone into everything. We have specifically
Yes,
taken
I
the ground
remember.
in
You
the
have-
written argument. My lord will find
Yes.
that it is para 11. Last three lines.
Para 11.
Internal page 13 of the written argument, 1-3. Last three lines.
Yes.
Para 11, last three lines, internal page 13. Labor court also did not record any finding as to whether the workman indeed met the required productivity norms set by the NPC in terms of the settlement.
Okay.
You don't deal with the fundamental, you deal with the ancillary issues, you call it a camouflage, you misinterpret it, you argue against yourself. One line you say one thing, another line you say another thing. This is how below the entire award is written. So therefore, below exclusively, it falls within the domain of where it is certiorari. My lord will interfere with it. That's my humble submission.
Okay.
But I don't think anything else is left. Onus is on them. Obviously, onus is on them. Yellati judgment I have referred to. Yellati case in paragraph 12.
RM, yes.
Para
Para
12.
17.
Para 12.
No, no.
There is
In that
continuity of
decision, para
service.
17.
Yes. Yes. Para 17. Para 17. Not
This,
para
this
17.
decision is for
My lord,
Onus.
in this case, my lord, the workers, my lord, they wanted
Mr. Tiwari, in your written argument, you are referring to only one decision, correct?
no many, my lord, several.
No, why I'm asking is, if possible, if your junior can just give me a photocopy of the decisions.
Then, my lord, all the decision we will furnish the photocopy.
You can just give it to the
yes,
postmaster. If
Number of
possible,
judgments, my
give
lord?
it by Saturday because next week I'll not be here.
By tomorrow,
I will
by tomorrow
reserve this
itself it
and
will be done. By
probably
tomorrow
I
it will
will
be handed
carry
over.
it. So
So, Yellati,
you have
my lord,
already given the
Yes.
photocopy.
so, my lord,
While
Yellati-
asking photocopies, then it will be easier for me to carry.
Yes. So,
Yes.
para 12, I am drawing your lordship's attention.
Yes, I have.
Para
to.
17 of the Yellati, onus is on them.
Yes.
They could have called for the records. They didn't because they know very well they have not met the target. That's all.
You please give the photocopies. You
Yes,
just
yes.
mark the paragraph kindly. All right.
On top of the photocopy itself,
Yes,
the paragraph
yes,
will be marked.
Rupak, mati dia. Itu NAK. I was thinking if possible to give the judgment in court, but I think it will need some
Yes.
amount of because
If my lord desires, my lord, so far as the worksheets are concerned, which we have given, how that is to be read, we can give a note on that if necessary.
is that
Otherwise,
required? Because
Very well.
strictly
Yes.
this court only has to see
yes,
if there is a
correct,
manifest
correct,
error.
correct,
That is
that's
the
all.
only
That's
thing.
all.
Yes.
Isn't
In the
it?
award itself,
It's
in the award itself,
award itself.
how they have dealt with it.
So this part, I
Correct,
don't think
correct.
there is any
Correct,
dispute. So
correct.
only thing before I go to that, what this court has to lay down is the conditions.
Yes.
That this is the settlement and this is the condition, because that settlement is binding, and I accept the argument of Mr. Das Gupta that it has the force
Same
of
here,
law.
my lord, we also accept
Now the question is whether this has been
fulfilled.
fulfilled or not.
Where is the
Compared.
finding? Where is the finding on that?
Correct. So that anyway, I will have to check, and then if I find that there is a manifest error, then I shall interfere. If I don't find, then I will not. This is the only course I have to do. Correct. If anything is required, any clarification, I will certainly get it relisted and take the advantage of your assistance. Good.
Only new point I had raised here that whether settlement has a
Yes, you have given that in your argument.
new point. Only
See, that point this court is accepting.
yes.
The court is accepting
Yes, I
your argument on that.
Hmm.
But merely because I am accepting doesn't mean everything
Yes,
comes in
yes.
place. Now we have to
Error-
test the settlement, what is the condition,
Yes.
and what has been done.
And whether there is manifest error or not.
Correct.
Not only error of law, this much. I'm deeply obliged to that because your lordship allowed me to,
No, there is
add
no
one another
question of
point.
not allowing you.
and I also grateful to him also.
We agree with that point.
Always accommodating.
We agree with that point. There is no quarrel on the principle.
Absolutely, there is
That
no
the award is
Only
binding.
yeah, award is binding upon what I
the
have.
settlement.
Settlement binding of what I wanted to place it before lordship. This has a force of law. It should be constituted as a statute.
Oh, yes, it is.
Even
That is why.
If it is considered as a
Assuming
statute,
that is correct, the next question is, it comes down to that. What are the conditions?
yes,
That's
Whether
it.
those conditions have been fulfilled. or not.
It was equally binding on the labor court.
Correct. The labor court cannot travel beyond
Definitely,
the scope of
definitely,
the
definitely.
settlement.
Hmm.
He cannot rewrite the settlement. Arguments concluded. Judgment reserved. Okay.
Well.
All right. What is this criminal appeal?
This is a appeal against conviction. Conviction, basically 376. 10 years.
Hello, before my learner can start, may I take the IA file? Because
Here is a,
my office
I have the
lost the
copy. I
petition.
have the copy.
Rupa.
Full judgment.
APP did
My lord,
I have given. Judgment কোথায় আছে? Evidence খিনি আছে।
এইখন তাৰ লগত দি দিব লাগে নেকি? Yes,
Matter was partly hard.
I do not remember. I'm sure as you take me, it will be refreshed.
It's not true. The allegation against the accused person is there.
All the how many PWs?
6 PWs.
They are all there in the paper book.
PW 1 is the victim.
No. All the testimonies are available here.
Yes, that's it.
Available in the petition. Have you annexed them?
Yes.
Okay. Yes. Where is the FIR?
FIR in the record lodge.
The records. Where is the FIR? Yes.
Read the FIR.
FIR খনে
There is an index perhaps.
I can't find it.
This is the FIR.
Just have a look, you mark it. Mr. Kaushik.
Index টা দিয়া নাই। Evidence. Second way.
And also mark all the testimonies, because I think they are already there in the front. I have
Yes,
seen
ma'am.
PW.
Only FIR, madam. It is in vernacular, ma'am.
It's in vernacular.
Shall I read?
Read it.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই বৰসত্ৰ গাঁৱৰ এগৰাকী ছোৱালী যোৱা ইংৰাজী 22 তাৰিখে 2022 তাৰিখে দিনৰ প্ৰায় 11:30 মান বজাত মই ঘৰত অকলশৰে আছিলোঁ। মোৰ মা দেউতাৰ ঘৰত কোনো নাছিল। দেউতা
table which your lordship will find in the very beginning middle of this case, or paragraph 31 and 32 of Sarla Verma case. That has to be seen. So what has been provided in penalty, my lord, is that conventional sum, loss of consortium, there has to be an increase of 15.
Are you ready?
Yes, Lord, sir.
These three factors are there. In conclusion, that becomes up. If we can come to the facts of the case, we come to the judgment. Lord.
Yes. Yes.
Accident Milord 7/5/2015 Milord.
Yes.
That on the same day Milord.
Yes.
The claimant examined 2 witnesses Milord. The defense also examined 2 witnesses. Thereafter Milord, the tribunal awarded a compensation of rupees 9,65,556 Milord with interest at the rate of 7.5%. Milord, may kindly see the calculation that will come in the judgment, page 12 of the appeal, Milord. Issue number 2. Issue number 1 is not in dispute. The accident, the liability, the.
What is issue number 1?
Issue number 1 is, Milord, the accident and the liability of the insurance company.
So there is no dispute.
That is not a dispute. Because they have already deposited the awarded sum.
Flat. Diba. Flat. Oh, assess. Sorry. Yes.
Page 12, Lord.
Yes, read.
Mary, if so, whether issue number 2, Milord, I am reading. If so, whether the claimant are entitled to receive any compensation, and if yes, what should be the quantum, and who among the opposite party is liable to pay the compensation amount? In view of the discussion and decision on foregoing issue, where number it is held, the claimant is entitled to get compensation. Now, let me decide what should be just and proper compensation under the facts and circumstances. In the case of Sarla Verma so-and-so reported in so-and-so, the Honorable Supreme Court has said, basically only 3
Mr.
facts.
Lal, you are the claimant.
I am the claimant. Yes, we have come for enhancement of compensation. In the case of Sarla Verma versus Delhi Transport Corporation reported in 2009, 6 SSC 121, the Honorable Supreme Court has held that basically only 3 facts need to be established by the claimant for assessing compensation in case of death. A, age of the deceased; B, income of the deceased; and C, the number of dependents. The issue to be determined by the tribunal to arrive at the loss of dependency are addition deduction to be made for living, for arriving at the income, the deduction to be made toward the personal living expenses of the deceased, and the multiplier to be applied with reference to the age of the deceased. The claimant in the claim petition stated that Srisram Chaudhary died at the age of 42 years. The postmortem report agreed for revealed deceased at the age of 43. Deceased at the age of 43. Accordingly, it is held at the time of decease was between the age of 41 to 45 years, and the appropriate multiplicand shall be 14 for ascertaining the loss of dependency. This factor is also not in dispute. Now, coming to the question of income of the deceased, the claimant in the evidence stated that at the time of the death, her husband was a businessman and his monthly income was 30,000. But the claimant has not proved the income of the deceased. Hence, in the absence of any positive evidence of income of the deceased, and considering the present state of economy and price rise, rupees 6,500 per month is taken as the income of the deceased for ascertaining the loss of dependency, as it cannot be ruled out as an able-bodied person.
So here, you have not proved the income.
Milord, we have exhibited, Milord, the RC, Milord, my driving.
RC means?
The registration certificate of my vehicle, Milord.
How does that matter?
Milord, I am the owner of a truck, Milord. If I am an owner of a truck, if I have a driving license, Milord, definitely I will have some income, Milord.
No, but what will be the income? There has to be some yardstick to come to a finding.
Yes,
generally, you should have brought in evidence.
Yes, Milord, but
now you are claiming that your monthly income was 30,000. This is what your claim is. But what have you brought? Your RC cannot be a proof for your monthly income.
Some guesswork is permissible for the
yes,
part
but
of
how,
the
from the RC
if
registration
I
certificate.
have
My logic says how absolutely not, because all right, it appears that you are a owner of the truck. Now, what you are doing with the truck?
Because I have a driving license.
No. What
run a
are you?
transport
Are you
vehicle,
using
Milord.
this truck for commercial purpose?
Yes, Milord.
What are you using it? Where are all those evidence?
That evidence for
Is not
a
there.
person who is running a truck will be very difficult. That also on the part of the wife. Milord.
You are the wife. Oh,
Yes, sir. Husband has
okay.
died,
All right.
Milord. So 6,500. This is a dependency. Milord. This is the calculation that need not be. Milord. Lordship, next page come to Milord.
One second. You complete that para 21.
Para 21. As the deceased was below the age of 50 years, placing reliance on a decision of the Supreme Court in Pranayasati, this is civil division number so and so, and added the income of deceased what future prospect as per a decision of the Honorable Supreme Court in special leave petition number so and so disposed of on 2017. Addition of 25% was granted. Lord.
And then because surviving two sons,
one son,
wife,
and one wife. Lord. Two persons.
Okay.
One son and wife. So by dependencies to the claim,
1/3.
Two surviving legal heirs, wife and son.
Therefore, this is the head. Income
Yes.
6,500, 25% of so and so. Then 1/3 of so and so is deducted. Compensation after multiplier 14, which you are not disputing. It is 9,10,000.
9,65,000 is coming. Next page, paragraph 25.
Yes.
9,65,000. No, award.
Yes, what is wrong?
Blood will come to that. Award and order. Blood. Next paragraph.
Yes.
Paragraph 27. Blood. Here, 7.5% interest was granted from the date of the filing of the evidence. That's the mechanism. Accordingly, the National Insurance Company Limited directed to make the payment of so and so within a period of 3 months from today. The compensation amount shall carry an interest at the bank rate for fixed deposit from 03/2017. Record revealed that although the case was filed by the claimant on 4/9/2015, around 3 years back, but the claimant could reduce evidence only on 3/2/2017. As such, I do not find any reason to direct the insurance company concerned to pay interest from the date of the filing of the claim petition per annum, and in the event of the failure to make the payment. So, from the date of the filing of the evidence, interest was granted. I have 4 contention in the matter. 1, my income. 2nd, rate of interest. It should be from the date of the filing of the claim petition. 3rd is the rate 7.5% was granted.
1 second. Second is from
interest should be granted from the
filing.
From the date of the filing.
And third?
Third, rate of interest should be 12 to 18% in between.
Yes.
7.5% was granted.
Rate of interest should have been
12 to 18% in between. It should be minimum 12%.
Here it has been given
7.5% was granted.
Where is it?
That is paragraph 27 itself.
Yes, 1%.
Yes, 1%.
This
so
is
additional interest of 1%.
This is what you are saying.
Yes, it was 7.5%. Just let me confirm. This is additional interest, so it was interest must have been earlier. That is not, that is missing. So there. Only 1% was granted, but Lordship should see that it remains that here additional interest that is of 1% per annum from the date of the filing of the claim petition. It is there. Third line below, if I may read.
One second.
The compensation amount.
One second. Are you carrying any authority to sue in similar situation?
Yes.
What are you carrying?
One line, the compensation amount shall carry an interest at the bank rate for fixed deposit from 3 to 2007.
Wait.
Paragraph 27, third line.
Oh, yes.
The compensation amount shall carry. And if not, then there is additional of 1%.
No, shall carry an interest.
Yes, shall carry
At
an
the
interest
bank rate.
At the bank rate for fixed deposit from. Interest is basically governed by 171. We'll come to that now. Now, so far as the loss of income is concerned,
Because you see, you are right that one can go into hypothesis, but that has to be objective, based on some objective, isn't it?
it is very difficult for a truck driver, a truck owner, Milord, to prove.
So that is why I am saying, in a similar,
Yes, there are.
what is the range in case of a death of a truck owner? Here, dependency 2.
Two dependencies. And one of the dependent leader, if I take your lordship to the paper book, one of the dependent leader was studying in school, Milord. Lordship, it only puts up the record.
Where is the case law?
Lordship, yes.
Let me have a look.
Eligible.
Yes.
First is in the Madras High Court, Milord, paragraph 4. Married, Milord.
Yes.
On a careful consideration of the contention of the learned counsel for the appellant, it could be seen that almost in 70 to 80% of the accident cases, the claimant are not able to produce any evidence with regard to the income of the deceased. Only in case of employed persons, we can expect the salary certificate, and in some cases, if it is an income tax assessee, we can expect some evidence with regard to the income of the deceased. If a person who dies in the accident is self-employed and not an assessee, in those cases, the tribunal as well as this court has to proceed to find out the income of the deceased on the basis of the nature of employment of the deceased. In this case, the deceased has been selling raffle ticket. On a hypothetical basis, the tribunal fixed a sum of 1,000 monthly income of the deceased. So 70 to 80% of the cases.
This is understood, but how does this help?
This lays the principle, Milord. Second case is a
What is the principle?
In a lot.
Yes.
The second is with regard to a truck.
You see, the same thing has happened. The tribunal have assessed. The tribunal have quantified it at 6,000 something.
A truck driver, we can always expect an income from a truck, owner of a truck. Because the owner of a truck, that is not in dispute. Second case, Milord, the New Indian Insurance Company, Lordship has Milord. In this case, the accident happened in 2008. And if you Lordship sees the paragraph 2 and 3, we start from paragraph. The insurer questioned the abart on the ground of loss of dependency was wrongly calculated at the income of 15,000.
See, there are evidences in this case.
No, Milord.
No, it is saying the deceased, it was proved, was owner of a truck and earning his livelihood from transport business. The evidence clearly shows that he was paying equated monthly installments to repay the loan taken for purchase of the said vehicle. In these circumstances, the finding on the issue of income is not disturbed.
Yes.
So that's why I'm asking, what is there? There has to be something.
Yes.
Simply you are a truck driver, truck owner will not do. There must be
Truck
something.
owner and I have a license. These two factors are.
So that is what you are saying, but nothing more. Here there was evidence to show the loan that is being given. So that gives some idea as this is what he is earning. There has to be something. Merely because you're a truck owner and you are saying, give me 30,000. How can you say that? On what basis? Mr. Lal, do some more homework. We'll have it on another day. I'm not convinced. Yes, Mr. Goswami?
Yes, Lordship. Lordship, in this case, the truck was a mini truck, Lordship.
The truck was a
mini truck.
Mini truck.
Mini truck. With some income can definitely be presumed,
Of course,
but
of
not
course.
to the extent my learned friend is saying. 30,000 is not to the extent.
appears to be. Anyway, I am not in a position to make a comment, but there has to be some idea.
Some idea.
Now
So at least the bank passbook could have been produced to show
Correct,
regular
correct.
deposit of
Correct,
some amount
correct.
in the year.
Something.
Some savings instrument somewhere.
Because
that
just
he was
because
capable
he
of
has a
making so
valid
much of
license and
deposit.
he has an RC showing he's the owner.
Sometimes they become a liability also.
Which way,
Sometimes they become a
the
liability
tribunal
that has to be solved
has
off.
applied its mind and fixed 6,000
Yes,
something. I don't find anything wrong, unless of course you had shown something to show that minimum this is what
Yes,
you are getting.
Yes.
And with that, of course, that may not be the clear thing that only this much you get, because as it's a truck, he's a truck owner, he may not he may not be paying tax, or we don't know what are all that, correct? So that is a different thing. Some hypothesis you can work on, but absolutely blank.
I had made a study of notional incomes as decided by Supreme Court of various ages, right from 2003, 87, 2001, 2013, 2010, of different professions with different dependencies and different care. So this may come. Some corroborative evidence should have been there. Like
This
bank
is what-
passbook would have
this
been
is
1
what
year.
I am
Bank passbook.
something.
Or maybe repayment of loan.
In this
that he had the
case which
capacity
Mr.
to.
Lal is relying,
Yes.
there is evidence to show that he is paying monthly installments
Yes, Lordship. Some evidence.
to repay the loan taken for purchasing that said vehicle. So something has been showing that
Yes,
this
yes.
much, the fact that he's paying this a amount indicates that he's earning that, and of course more than that, isn't it?
Yes,
So
sir.
something on record has come.
I'm saying all material facts. How many persons were dependent? What was the position?
You have
Like
a
from
truck
manager-
driver, truck owner, no.
No, it's a manager. Is there are various kinds of occupations. So what the Supreme Court do in fact? You're saying?
Let him do some more
Yes,
homework.
yes, yes.
Mr. Lal? When?
Next week,
No, next week I think we fixed a lot of matters. After 1 week, you 1 week is back, you can give it again. It will get misplaced.
but you can keep it part-time.
No, not part-time.
September.
These all decisions you have given right now,
Yes.
Manusha, Sri Kumar.
Not,
On interest.
not going. So, in one case, that is two cases, their truck driver. In 2000, last case, 2008 accident, 9,000 was presumed.
No, Mr. Lal, have you understood the query? You see, to draw that presumption, some material, something needs to be there.
Yes, I understand that. But the record.
Okay, because otherwise, simply because on the basis of a RC and the driving license, 30,000 cannot be given to you. Are you following what I am saying?
I agree with that.
Because the tribunal is the court which has gone into all the evidences, applied its mind, adopted the correct multiplier, and has come to has quantified. Now you want to enhance. So you have to show
I will try.
that there is some erroneous, the error is there.
Tribunal judgment, there is error, Prima facie means it says I'm a businessman, only that much.
No, not that. There has to be
Customer
something
trust
more.
Or the license has not been considered.
Hearing could not be completed. List on such. Kitya Disa?
Publish.
बोल लीजिए
Does it, should I take the judgment spec, Lord?
Yes, it is your judgment. It's hard control.
May it please your lordship. Lordship, in this case, there is some confusion occurred in the part of the respondent. The client, without informing us or without taking any NOC from us, he has engaged
Another set.
Yes, 2 counsels.
You sort it out.
Mhm.
We have no clue about that.
No, that's it. There are 2 Wakalatnama filed.
But
You sort it out. By this practice is not good if NOC has not been obtained from the present set of counsel. In fact, the second set of counsel ought not have been engaged.
Yes.
Before accepting a brief, the second set of counsel should always insist that an NOC is given. This is the practice we used to
And when we had come to know in the
do.
last,
I don't know what is happening in today's generation, but this is the practice which should be
in
followed.
the-
Otherwise, it will be very difficult.
in the last date,
This
when
is
it
not
was,
appreciated.
last
You are
date,
the new set.
yes,
So
Mr. M.A. Sheikh was engaged. I'm on his behalf.
no, but have you heard the submission? You were aware that there was that the
I was
response,
not aware of that fact.
but subsequently you must have come to know because the cause title also shows their name. You please sort it out because this is not appreciated. And
Lordship,
these matters should not even reach before the bench.
yes.
Right.
You should sort it out and do it in an ethical manner.
If I'm allowed, I would like to submit one sentence that this petition has become infructuous.
That is a different thing. Yeah, and infractions that will come from the petitioner. You are the petitioner.
Yes.
That prayer they have filed it for transfer. Has it
Uh,
become infractious?
No.
And when the case was listed on the last date, but due to paucity of time, it was not reached. Thereafter, we have contacted our client. Then means we have to send a letter to him. So there was no any proper response on his behalf. So we need some more time to seek his response.
No, I'm
That-
giving you the time, but what
Okay.
I'm saying is that
Yeah.
it is very unfortunate in the day if
is.
such submissions are made before the bench. These are matters for the bar to sort it out amongst themselves. I'm not recording anything in the order, but
Okay.
it's extremely unfortunate. Sort it out and follow the ethics. Due to as prayed for by MS,
A. Bora.
A. Bora, Learned Counsel for the respondent, list this matter after 2 weeks on a date to be fixed by the registry to enable the Learned Counsel for the respondent to obtain instruction in the matter in view of the fact that while the Learned Counsel has been engaged to appear in the matter on behalf of the respondent, another set of lawyer appears to have been engaged by the respondent.